Please subscribe, like and share this content. It means a lot to us. Thank you in advance. Cornell Law School, U.C.C, Article 4, Bank Deposits and Collections, Part 2, Collection of Items, Depositary and Collecting Banks. Paragraph 4201. Status of collecting bank as agent and provisional status of credits. Applicability of Article. Item endorsed. Pay any bank. A. Unless a contrary intent clearly appears and before the time that a settlement given by a collecting bank for an item is or becomes final, the bank, with respect to the item, is an agent or sub-agent of the owner of the item, and any settlement given for the item is provisional. This provision applies regardless of the form of endorsement or lack of endorsement, and even though credit given for the item is subject to immediate withdrawal as of right or is in fact withdrawn, but the continuance of ownership of an item by its owner and any rights of the owner to proceeds of the item are subject to rights of a collecting bank, such as those resulting from outstanding advances on the item and rights of recoupment or set-off. If an item is handled by banks for purposes of presentment, payment, collection, or return, the relevant provisions of this article apply even though action of the parties clearly establishes that a particular bank has purchased the item and is the owner of it. B. After an item has been endorsed with the words, "Pay any bank" or the like, only a bank may acquire the rights of a holder until the item has been 1. Returned to the customer initiating collection, or 2. Specially endorsed by a bank to a person who is not a bank. Paragraph 4202. Responsibility for collection or return. When action timely. A collecting bank must exercise ordinary care in 1. Presenting an item or sending it for presentment. 2. Sending notice of dishonor or non-payment or returning an item other than a documentary draft to the bank's transferor after learning that the item has not been paid or accepted, as the case may be. 3. Settling for an item when the bank receives final settlement, and 4. Notifying its transferor of any loss or delay in transit within a reasonable time after discovery thereof. B. A collecting bank exercises ordinary care under subsection A by taking proper action before its midnight deadline following receipt of an item, notice, or settlement. Taking proper action within a reasonably longer time may constitute the exercise of ordinary care, but the bank has the burden of establishing timeliness. C. Subject to subsection A. 1. The bank is not liable for the insolvency, neglect, misconduct, mistake, or default of another bank or person or for loss or destruction of an item in the possession of others or in transit. Paragraph 4203. Effect of instructions. Subject to Article 3 concerning conversion of instruments, Section 3420, and restrictive endorsements, Section 3206, only a collecting bank's transferor can give instructions that affect the bank or constitute notice to it, and the collecting bank is not liable to prior parties for any action taken pursuant to the instructions or in accordance with any agreement with its transferor. Paragraph 4204. Methods of sending and presenting. Sending directly to payer bank. A collecting bank shall send items by a reasonably prompt method, taking into consideration relevant instructions, the nature of the item, the number of those items on hand, the cost of collection involved, and the method generally used by it or others to present those items. B. A collecting bank may send 1. An item directly to the payer bank, 2. An item to a non-bank payer if authorized by its transferor, and 3. An item other than documentary drafts to a non-bank payer if authorized by Federal Reserve regulation or operating circular, clearinghouse rule, or the like. C. Presentment may be made by a presenting bank at a place where the payer bank or other payer has requested that presentment be made. Paragraph 4205. Depositary bank holder of unendorsed item. If a customer delivers an item to a depositary bank for collection, 1. The depositary bank becomes a holder of the item at the time it receives the item for collection if the customer at the time of delivery was a holder of the item, whether or not the customer endorses the item, and, if the bank satisfies the other requirements of Section 3302, it is a holder in due course, and 2. The depositary bank warrants to collecting banks, the payer bank or other payer, and the drawer that the amount of the item was paid to the customer or deposited to the customer's account. Paragraph 4206. Transfer between banks. Any agreed method that identifies that transferor bank is sufficient for the item's further transfer to another bank. Paragraph 4207. Transfer warranties. A customer or collecting bank that transfers an item and receives a settlement or other consideration warrants to the transferee and to any subsequent collecting bank that 1. The warrantor is a person entitled to enforce the item. 2. All signatures on the item are authentic and authorized. 3. The item has not been altered. 4. The item is not subject to a defense or claim in recoupment. Section 3305A of any party that can be asserted against the warrantor. And 5. The warrantor has no knowledge of any insolvency proceeding commenced with respect to the maker or acceptor or, in the case of an unaccepted draft, the drawer. And 6. With respect to any remotely created consumer item, that the person on whose account the item is drawn authorized the issuance of the item in the amount for which the item is drawn. B. If an item is dishonored, a customer or collecting bank transferring the item and receiving settlement or other consideration is obliged to pay the amount due on the item, I, according to the terms of the item at the time it was transferred, or 2. If the transfer was of an incomplete item, according to its terms when completed as stated in sections 3115 and 3407. The obligation of a transferor is owed to the transferee and to any subsequent collecting bank that takes the item in good faith. A transferor cannot disclaim its obligation under this subsection by an endorsement stating that it is made, without recourse or otherwise disclaiming liability. C. A person to whom the warranties under subsection A are made and who took the item in good faith may recover from the warrantor as damages for breach of warranty an amount equal to the loss suffered as a result of the breach, but not more than the amount of the item plus expenses and loss of interest incurred as a result of the breach. D. The warranties stated in subsection A cannot be disclaimed with respect to checks, unless notice of a claim for breach of warranty is given to the warrantor within 30 days after the claimant has reason to know the breach and the identity of the warrantor is discharged to the extent of any loss caused by the delay in giving notice of the claim. E. A cause of action for breach of warranty under this section accrues when the claimant has reason to know of the breach. Paragraph 4208. Presentment warranties. A. If an unaccepted draft is presented to the drawee for payment or acceptance and the drawee pays or accepts the draft, I, the person obtaining payment or acceptance, at the time of presentment, and 2. A previous transferor of the draft, at the time of transfer, warrant to the drawee that pays or accepts the draft in good faith that 1. The warrantor is, or was, at the time the warrantor transferred the draft, a person entitled to enforce the draft or authorized to obtain payment or acceptance of the draft on behalf of a person entitled to enforce the draft. 2. The draft has not been altered, and 3. The warrantor has no knowledge that the signature of the purported drawer of the draft is unauthorized, and 4. With respect to any remotely created consumer item, that the person on whose account the item is drawn authorized the issuance of the item in the amount for which the item is drawn. B. A drawee making payment may recover from a warrantor damages for breach of warranty equal to the amount paid by the drawee less the amount the drawee received or is entitled to receive from the drawer because of the payment. In addition, the drawee is entitled to compensation for expenses and loss of interest resulting from the breach. The right of the drawee to recover damages under this subsection is not affected by any failure of the drawee to exercise ordinary care in making payment. If the jury accepts the draft, I. Breach of warranty is a defense to the obligation of the acceptor, and 2. If the acceptor makes payment with respect to the draft, the acceptor is entitled to recover from a warrantor for breach of warranty the amount stated in this subsection. C. If a jury asserts a claim for breach of warranty under subsection A based on an unauthorized endorsement of the draft or an alteration of the draft, the warrantor may defend by proving that the endorsement is effective under Section 3404 or 3405 or the drawer is precluded under Section 3406 or 4406 from asserting against the jury the unauthorized endorsement or alteration. D. If I. A dishonored draft is presented for payment to the drawer or an endorser or 2. Any other item is presented for payment to a party obliged to pay the item, and the item is paid, the person obtaining payment and a prior transfer of the item warrant to the person making payment in good faith that the warrantor is, or was, at the time the warrantor transferred the item, a person entitled to enforce the item or authorized to obtain payment on behalf of a person entitled to enforce the item. The person making payment may recover from any warrantor for breach of warranty an amount equal to the amount paid plus expenses and loss of interest resulting from the breach. E. The warranty is stated in subsections A and D cannot be disclaimed with respect to checks, unless notice of a claim for breach of warranty is given to the warrantor within 30 days after the claimant has reason to know of the breach and the identity of the warrantor. The warrantor is discharged to the extent of any loss caused by the delay in giving notice of the claim. F. A cause of action for breach of warranty under this section accrues when the claimant has reason to know of the breach.